FAQs on Customs Act 1962, Section 31. Grant of Entry Inward. Q1. What is Section 31 of the Customs Act 1962 about? Answer. Section 31 deals with the grant of entry inward to a vessel or aircraft arriving in India from a place outside India. Q2. What is meant by entry inward? Answer. Entry inward is the official permission granted by customs authorities allowing unloading of imported goods from a vessel or aircraft. Q3. Who grants entry inward? Answer. The proper officer of customs grants entry inward. Q4. When is entry inward granted? Answer. Entry inward is granted after the import manifest is delivered under Section 30 and necessary requirements are fulfilled. Q5. Can goods be unloaded before entry inward is granted? Answer. No. Goods cannot be unloaded until entry inward is granted, except with special permission. Q6. Why is entry inward important? Answer. Because legal unloading of imported goods is allowed only after entry inward. Q7. To which conveyances does Section 31 apply? Answer. Section 31 applies to vessels, aircrafts, arriving from outside India. Q8. Does Section 31 apply to coastal vessels? Answer. No. Section 31 applies only to foreign-going vessels and aircrafts, not coastal traffic. Q9. What happens if goods are unloaded without entry inward? Answer. Unloading without entry inward may result in confiscation of goods, penalty on the person in charge. Q. Thus, is entry inward linked with clearance of goods? Answer. Yes. Clearance procedures start only after entry inward is granted. Q11. Is Section 31 a charging section? Answer. No. Section 31 is not a charging section. It is a procedural provision. Q12. Why is Section 31 important for importers? Answer. It ensures proper customs control, lawful unloading and clearance of goods. FAQs on Customs Act 1962, Section 32. Unloading of imported goods. Q8. What is Section 32 of the Customs Act 1962 about? Answer. Section 32 regulates the unloading of imported goods from a vessel or aircraft arriving in India. Q2. When can imported goods be unloaded? Answer. Imported goods can be unloaded only after entry inward is granted under Section 31. Q3. Where can goods be unloaded? Answer. Goods must be unloaded only at approved places notified under Section 8. Q4. Who supervises the unloading of goods? Answer. Unloading is done under the supervision of customs authorities. Q5. Can unloading be done at night or outside normal hours? Answer. Yes. Unloading may be allowed with permission of the proper officer and subject to conditions. Q6. Does Section 32 apply to all imported goods? Answer. Yes. Section 32 applies to all imported goods unless specifically exempted. Q7. Can goods be unloaded before entry inward in emergencies? Answer. Yes. In cases of emergency or unavoidable circumstances, unloading may be allowed with special permission. Q8. What happens if goods are unloaded without permission? Answer. Such goods are liable to confiscation, penalty on the person in charge. Q9. Is Section 32 applicable to coastal goods? Answer. No. Section 32 applies only to goods imported from outside India. Q. Thus, is Section 32 a charging section? Answer: no. Section 32 is not a charging section. It is a procedural provision. Q. 11. Why is Section 32 important? Answer: it ensures controlled unloading, prevention of smuggling or pilferage, proper customs supervision. Q. 12. Is Section 32 connected with other sections? Answer: yes. Section 30, Import Manifest. Section 31, Entry Inward. Section 32, Unloading of Goods. FAQs on Customs Act 1962, Section 33. Unloading of goods at approved places only. Q8. What is Section 33 of the Customs Act 1962 about? Answer: Section 33 provides that imported goods must be unloaded only at places approved by customs authorities. Q2. What is meant by approved places? Answer: approved places are proper places authorized under Section 8 within a customs port, airport, or land customs station. Q3. Why does Section 33 restrict unloading to approved places? Answer: to ensure customs supervision, prevention of smuggling, proper accounting and control of imported goods. Q4. Can goods be unloaded at any place within a port? Answer: no. Goods can be unloaded only at places specifically approved by the Commissioner of Customs. Q5. Who is responsible for unloading goods at approved places? Answer: the person in charge of the vessel or aircraft is responsible. Q6. What happens if goods are unloaded at an unapproved place? Answer: such goods are liable to confiscation, penalty under the Customs Act. Q7. Does Section 33 apply to unloading after entry inward? Answer: yes. Even after entry inward under Section 31, unloading must comply with Section 33. Q8. Is Section 33 applicable to all imported goods? Answer: yes. It applies to all imported goods unless specifically exempted. Q9. Does Section 33 apply to coastal goods? Answer: no. Section 33 applies to goods imported from outside India, not coastal traffic. Q. Thus, is special permission allowed for unloading at other places? Answer: generally no, except in emergency or unavoidable circumstances with customs permission. Q11. Is Section 33 a charging section? Answer: no. Section 33 is not a charging section. It is a procedural and control provision. Q12. Why is Section 33 important? Answer: it ensures safe, lawful, and controlled unloading of imported goods. FAQs on Customs Act 1962, Section 34. Goods not to be unloaded or loaded except under supervision of customs officer. Q8. What is Section 34 of the Customs Act 1962 about? Answer: Section 34 provides that no imported or export goods shall be unloaded or loaded except under the supervision of a customs officer. Q2. Why is supervision by customs officer required? Answer: to ensure prevention of smuggling, correct accounting of goods, compliance with customs laws. Q3. To which goods does Section 34 apply? Answer: Section 34 applies to imported goods, export goods. Q4. Who is responsible for ensuring supervision? Answer: The person in charge of the vessel, aircraft, or vehicle is responsible. Q5. Can unloading or loading be done without customs supervision? Answer: no, it is not allowed, except in special circumstances permitted by customs authorities. Q6. Does Section 34 apply to all ports and airports? Answer: yes, it applies to all customs ports, airports, and land customs stations. Q7. What happens if goods are loaded or unloaded without supervision? Answer: such goods are liable to confiscation, penalty under the Customs Act. Q8. Is supervision required even after entry inward or entry outward? Answer: yes, entry inward or entry outward does not remove the requirement of supervision. Q9. Is Section 34 applicable to baggage? Answer: yes, it applies to goods and baggage handled under customs control. Q10. Is Section 34 a charging section? Answer: no, Section 34 is not a charging section. It is a control and procedural provision. Q11. Why is Section 34 important? Answer: it ensures transparency in handling of goods, protection of government revenue, effective customs enforcement. Q12. Is Section 34 linked with other sections? Answer: yes. Section 31, entry inward. Section 32 stands unloading rules. Section 34, supervision by customs officer. FAQs on Customs Act 1962, Section 34. Goods not to be unloaded or loaded except under supervision of customs officer. Q8. What is Section 34 of the Customs Act 1962? Answer: Section 34 states that imported or export goods cannot be unloaded or loaded except under the supervision of a customs officer. Q2. What is the main purpose of Section 34? Answer: the purpose is to prevent smuggling, ensure proper accounting of goods, protect government revenue. Q3. To which goods does Section 34 apply? Answer: it applies to imported goods, export goods, including baggage, where applicable. Q4. Who must ensure customs supervision? Answer: the person in charge of the conveyance, ship, aircraft, or vehicle must ensure supervision by customs. Q5. Is customs supervision required even after entry inward or entry outward? Answer: yes, even after entry inward, imports, or entry outward, exports, customs supervision is mandatory. Q6. Can goods be unloaded or loaded without supervision in emergencies? Answer: only in exceptional or emergency situations and with permission of the customs authorities. Q7. What happens if goods are loaded or unloaded without customs supervision? Answer: such goods are liable to confiscation, penalty under the Customs Act. Q8. Does Section 34 apply at all ports and airports? Answer: yes, it applies at all customs ports, airports, and land customs stations. Q9. Is Section 34 a charging section? Answer: no, Section 34 is not a charging section. It is a procedural and control provision. Q10. How is Section 34 connected with other sections? Answer: Section 34 works together with Section 31, entry inward. Section 32-33, unloading of goods. Section 34, mandatory customs supervision. Q11. Why is Section 34 important for importers and exporters? Answer: because violation can lead to confiscation of goods, penalties, and delays in clearance. FAQs on Customs Act 1962, Section 35. Restrictions on unloading and loading of goods. Q8. What is Section 35 of the Customs Act 1962 about? Answer: Section 35 places restrictions on the unloading of imported goods and loading of export goods, except under conditions specified by customs authorities. Q2. What is the main purpose of Section 35? Answer: 2. Prevent unauthorized handling of goods. Ensure customs control. Protect government revenue. Q3. To which goods does Section 35 apply? Answer: Section 35 applies to imported goods, export goods. Q4. Who enforces the restrictions under Section 35? Answer: the proper officer of customs enforces these restrictions. Q5. Can unloading or loading be done at any time? Answer: no. Unloading or loading can be done only during prescribed hours or as permitted by the customs officer. Q6. Can goods be handled without customs permission? Answer: no. Handling of goods without customs permission or supervision is not allowed. Q7. What happens if Section 35 is violated? Answer: violation may result in confiscation of goods, penalty on the person responsible. Q8. Does Section 35 apply even after entry inward or entry outward? Answer: yes. Even after entry inward, imports, or entry outward, exports, Section 35 restrictions continue to apply. Q9. Is Section 35 applicable to coastal vessels? Answer: no. It applies mainly to goods imported from or exported to places outside India. Q. Thus, is Section 35 a charging section? Answer: no. Section 35 is not a charging section. It is a procedural provision. Q11. Why is Section 35 important? Answer: it ensures orderly customs operations, prevention of illegal loading-unloading, effective customs supervision. Q12. How is Section 35 linked with other sections? Answer: Section 35 works with Section 32, unloading of goods. Section 33, unloading at approved places. Section 34, supervision by customs officer. FAQs on Customs Act 1962, Section 36. Restrictions on unloading or loading of goods on holidays. Q8. What is Section 36 of the Customs Act 1962 about? Answer: Section 36 places restrictions on unloading of imported goods and loading of export goods on holidays. Q2. What is meant by holiday under Section 36? Answer: a holiday means a day notified as a holiday for customs offices, including public holidays, Sundays, any other day declared as a customs holiday. Q3. Is unloading or loading of goods allowed on holidays? Answer: no. Unloading or loading is not allowed on holidays unless special permission is granted by the proper officer of customs. Q4. Who can grant permission to work on holidays? Answer: the proper officer of customs may grant permission subject to conditions. Q5. Why does Section 36 restrict operations on holidays? Answer: to ensure availability of customs supervision, proper control and security of goods, prevention of illegal handling, Q6. Does Section 36 apply to both imports and exports? Answer: yes. Section 36 applies to imported goods, unloading, export goods, loading. Q7. Are emergency situations covered under Section 36? Answer: yes. In emergency or unavoidable circumstances, permission may be granted for loading or unloading on holidays. Q8. What happens if goods are loaded or unloaded on a holiday without permission? Answer: such goods are liable to confiscation, penalty under the Customs Act. Q9. Does Section 36 apply after entry inward or entry outward? Answer: yes. Even after entry inward or entry outward, holiday restrictions continue to apply. Q10. Is Section 36 applicable at all customs stations? Answer: yes. It applies to all customs ports, airports, and land customs stations. Q11. Is Section 36 a charging section? Answer: no. Section 36 is not a charging section. It is a procedural and control provision. Q12. Why is Section 36 important? Answer: it ensures disciplined customs operations, proper supervision, prevention of unauthorized movement of goods. FAQs on Customs Act 1962, Section 37. Power to allow unloading or loading on holidays and outside working hours. Q8. What is Section 37 of the Customs Act 1962 about? Answer: Section 37 empowers the Commissioner of Customs to allow unloading of imported goods or loading of export goods on holidays or outside normal working hours. Q2. Why is Section 37 needed? Answer: because Sections 35 and 36 restrict loading-unloading on holidays or outside working hours, Section 37 provides flexibility in special cases. Q3. Who has the authority under Section 37? Answer: the Commissioner of Customs has the authority to grant permission. Q4. Is special permission required for unloading or loading under Section 37? Answer: yes. Permission must be specifically granted by the Commissioner of Customs. Q5. Does Section 37 apply to both imports and exports? Answer: yes. It applies to unloading of imported goods, loading of export goods. Q6. Can permission under Section 37 be conditional? Answer: yes. Permission may be granted subject to conditions, such as payment of overtime charges. Q7. Are overtime fees applicable under Section 37? Answer: yes. The person concerned may be required to pay overtime fees for customs officers. Q8. Does Section 37 override Sections 35 and 36? Answer: yes. Section 37 provides an exception to the restrictions imposed by Sections 35 and 36. Q9. Is Section 37 a charging section? Answer: no. Section 37 is not a charging section. It is a procedural provision. Q10. Why is Section 37 important? Answer: it facilitates smooth trade operations, avoidance of delays in urgent shipments, balance between trade facilitation and customs control. Q11. Does Section 37 apply to all customs stations? Answer: yes. It applies to all customs ports, airports, and land customs stations. Q12. What happens if loading-unloading is done without permission under Section 37? Answer: such action may lead to penalty, confiscation of goods. FAQs on Customs Act 1962, Section 38. Power to board conveyances. Q8. What is Section 38 of the Customs Act 1962 about? Answer. Section 38 gives customs officers the power to board any conveyance, ship, aircraft, or vehicle for the purpose of enforcing customs law. Q. Though, who can exercise powers under Section 38? Answer. Any officer of customs authorized under the Act can exercise this power. Q. 3. What is meant by conveyance under Section 38? Answer. Conveyance includes vessels, ships, aircraft, vehicles used for carrying goods or passengers. Q4. When can a customs officer board a conveyance? Answer. A customs officer may board a conveyance on arrival in India, while within Indian customs waters, at a customs port, airport, or inland location. Q5. Why is the power to board conveyances important? Answer. It helps customs authorities to prevent smuggling, verify goods, documents, crew, and passengers, ensure compliance with customs laws. Q6. Is prior permission required to board a conveyance? Answer. No. Customs officers can board a conveyance in the course of their official duties. Q7. Does Section 38 apply only to foreign-going vessels? Answer. It mainly applies to conveyances arriving from or going to outside India, but can also apply wherever customs control is required. Q8. Are persons in charge required to cooperate? Answer. Yes. The person in charge of the conveyance must provide assistance and access to customs officers. Q9. What happens if boarding is obstructed? Answer. Obstruction may result in penalty, further legal action under the Customs Act. Q. Thus, is Section 38 a charging section? Answer. No. Section 38 is not a charging section. It is an enforcement and control provision. Q11. Is Section 38 applicable throughout India? Answer. Yes. Section 38 applies to the whole of India, including customs waters. Q12. Why is Section 38 important? Answer. It strengthens customs enforcement, ensures lawful movement of goods, and protects government revenue. FAQs on Customs Act 1962, Section 39. Power to require production of documents and ask questions. Q8. What is Section 39 of the Customs Act 1962 about? Answer. Section 39 gives customs officers the power to require production of documents and to ask questions for enforcing the Customs Act. Q. Though, who can exercise powers under Section 39? Answer. Any officer of customs authorized under the Act can exercise these powers. Q3. From whom can documents be demanded? Answer. Documents can be demanded from the person in charge of a conveyance, importers or exporters, any person connected with import, export, or movement of goods. Q4. What type of documents can customs officers ask for? Answer. Documents such as bills of entry, shipping bills, invoices, packing lists, import-export manifests, licenses, permits, or certificates. Q5. Can customs officers ask questions under Section 39? Answer. Yes. Officers may question any person regarding goods carried, ownership of goods, destination or origin, compliance with customs law. Q6. Is it mandatory to answer questions truthfully? Answer. Yes. Persons are legally bound to answer truthfully and produce required documents. Q7. Can statements recorded under Section 39 be used as evidence? Answer. Yes. Statements and documents obtained may be used as evidence in customs proceedings. Q. Art. What happens if a person refuses to produce documents or answer questions? Answer. Refusal or non-cooperation may lead to penalties, further legal action under the Customs Act. Q. No. Does Section 39 apply only at ports and airports? Answer. No. It applies anywhere customs officers are exercising lawful authority, including inland areas. Q. Thus, is Section 39 a charging section? Answer. No. Section 39 is not a charging section. It is an investigative and enforcement provision. Q. 11. Why is Section 39 important? Answer. It helps customs authorities to verify truthfulness of declarations, detect smuggling and evasion, ensure effective enforcement of customs law. Q. 12. Is cooperation under Section 39 compulsory? Answer. Yes. Full cooperation is mandatory when documents or information are lawfully required. FAQs on Customs Act 1962 Section 40. Power to stop and search conveyances. Q. 1. What is Section 40 of the Customs Act 1962 about? Answer. Section 40 empowers customs officers to stop and search any conveyance for enforcing the provisions of the Customs Act. Q. Though, what is meant by conveyance under Section 40? Answer. Conveyance includes vessels, ships, aircraft, vehicles used for carrying goods or passengers. Q. 3. Who can exercise powers under Section 40? Answer. Any officer of customs authorized under the Act can exercise the power to stop and search conveyances. Q. 4. When can a conveyance be stopped and searched? Answer. A conveyance can be stopped and searched when a customs officer has reason to believe that goods are smuggled or there is violation of customs law. Q. 5. Is a warrant required to stop and search under Section 40? Answer. No. No warrant is required for stopping and searching a conveyance under Section 40. Q. 6. Where can the search be conducted? Answer. Search may be conducted at ports, airports, land customs stations, on highways, in land areas, or customs waters, wherever customs jurisdiction applies. Q. 7. Are persons in charge required to cooperate? Answer. Yes. The person in charge of the conveyance must stop the conveyance, allow search, provide necessary assistance. Q. 8. What happens if a person refuses to stop or allow search? Answer. Refusal may result in seizure of goods, penalty, further action under the Customs Act. Q. No. Is Section 40 a charging section? Answer. No. Section 40 is not a charging section. It is an enforcement provision. Q. Thus, how is Section 40 different from Section 22? Answer. Section 22, power to stop and search conveyances generally. Section 40, specific power to stop and search conveyances during enforcement operations. Q. 11. Why is Section 40 important? Answer. It helps in preventing smuggling, ensuring lawful movement of goods, protecting government revenue. Q. 12. Is Section 40 applicable throughout India? Answer. Yes. Section 40 applies to the whole of India, including customs waters. FAQs on Customs Act 1962, Section 41. Power to search persons. Q. 8. What is Section 41 of the Customs Act 1962 about? Answer. Section 41 empowers customs officers to search persons for the purpose of enforcing customs law. Q2. Who can exercise the power under Section 41? Answer. Any officer of customs who is duly authorized under the Act can exercise this power. Q3. When can a person be searched under Section 41? Answer. A person may be searched when the customs officer has reason to believe that the person is carrying smuggled goods or goods liable to confiscation under the Customs Act. Q4. Does Section 41 apply only at ports and airports? Answer. No. Section 41 applies anywhere within customs jurisdiction, including inland areas. Q5. Is a warrant required for searching a person under Section 41? Answer. You said. FAQ on Custom Act Section 42. ChatGPT said, here are FAQs, frequently asked questions, on Section 42 of the Customs Act, 1962 explained in simple English, no images. FAQs on Customs Act 1962 Section 42. Power to search persons, safeguards. Q8. What is Section 42 of the Customs Act 1962 about? Answer. Section 42 provides safeguards and procedure to be followed while searching a person under the Customs Act. Q2. Why is Section 42 important? Answer. It protects the rights and dignity of individuals while allowing customs officers to conduct lawful searches. Q3. When does Section 42 apply? Answer. Section 42 applies when a person is searched under the powers given by the Customs Act, for example, under Section 41. Q4. Can a woman be searched by a male customs officer? Answer. No. A woman can be searched only by a woman customs officer. Q5. How should a personal search be conducted? Answer. The search must be conducted with decency and respect, in accordance with lawful procedure, without unnecessary force or harassment. Q6. Is the presence of witnesses required during search? Answer. Yes. As far as practicable, the search should be conducted in the presence of independent witnesses. Q7. Can customs officers detain a person for search? Answer. Yes. A person may be detained for a reasonable time for conducting a lawful search. Q8. What happens if a person resists search? Answer. Resistance may lead to use of reasonable force, legal action or penalty under the Customs Act. Q9. Are seized goods required to be documented? Answer. Yes. Any goods recovered during search must be properly recorded and documented. Q. Thus, is Section 42 a charging section? Answer. No. Section 42 is not a charging section. It is a procedural and protective provision. Q11. How is Section 42 linked with other sections? Answer. Section 41. Power to search persons. Section 42. Procedure and safeguards for such search. Q12. Why should citizens know about Section 42? Answer. It helps individuals understand their legal rights during customs searches and ensures lawful enforcement. FAQs on Customs Act 1962 Section 42. Search of persons, safeguards and procedure. Q8. What is Section 42 of the Customs Act 1962? Answer. Section 42 lays down the procedure and safeguards to be followed while searching a person under the Customs Act. Q2. Why is Section 42 important? Answer. It ensures that personal searches are conducted lawfully with respect for dignity and rights of individuals. Q3. When does Section 42 apply? Answer. Section 42 applies when a person is searched under customs law, especially under Section 41. Q4. Can a woman be searched by a male customs officer? Answer. No. A woman can be searched only by a woman customs officer. Q5. How should a personal search be conducted? Answer. The search must be conducted with decency and respect. Following legal procedure without unnecessary force or harassment. Q6. Are witnesses required during a personal search? Answer. Yes. As far as possible, the search should be conducted in the presence of independent witnesses. Q7. Can customs officers detain a person for search? Answer. Yes. A person may be detained for a reasonable time for conducting a lawful search. Q8. What happens if a person refuses to cooperate? Answer. Refusal may lead to use of reasonable force, legal action or penalty under the Customs Act. Q9. What happens to goods found during the search? Answer. Any goods found may be seized if liable to confiscation, properly documented and recorded. Q. Thus, does Section 42 apply everywhere in India? Answer. Yes. Section 42 applies to the whole of India. Q. 11. Is Section 42 a charging section? Answer. No. Section 42 is not a charging section. It is a procedural safeguard provision. Q. 12. How is Section 42 linked with other sections? Answer. Section 41. Power to search persons. Section 42. Procedure and safeguards for such search. Q. 13. Why should students and officers remember Section 42? Answer. Because it balances customs enforcement with protection of individual rights and is important for exams and practical enforcement. FAQs on Customs Act 1962, Section 43. Power to screen or X-ray baggage, goods or conveyances. Q8. What is Section 43 of the Customs Act 1962 about? Answer. Section 43 empowers customs officers to screen, scan, or X-ray baggage, goods, or conveyances for customs examination. Q2. Why is Section 43 important? Answer. It helps customs authorities to detect smuggled or prohibited goods, reduce physical searches, ensure quick and effective examination. Q3. What items can be screened or X-rayed under Section 43? Answer. Customs officers may screen passenger baggage, imported or export goods, conveyances, vehicles, aircraft, vessels. Q4. Who can exercise powers under Section 43? Answer. Any authorized officer of customs can exercise this power. Q5. Is physical search mandatory before screening? Answer. No. Screening or X-ray may be done instead of or before physical search. Q6. Does screening require consent of the passenger or owner? Answer. No. Screening is a statutory power, and consent is not required. Q7. What happens if suspicious items are detected during screening? Answer. Customs officers may conduct detailed physical examination, seize goods if liable to confiscation, take legal action under the Act. You said FAQ on Custom Act Section 44. ChatGPT said, here are FAQs, frequently asked questions, on Section 44 of the Customs Act 1962 explained in simple English. FAQs on Customs Act 1962 Section 44. Power to examine goods, baggage, containers. Q8. What is Section 44 of the Customs Act 1962? Answer. Section 44 gives customs officers the legal authority to examine goods, baggage, and containers. This includes inspecting contents to enforce customs laws. Q2. Why is Section 44 important? Answer. It helps customs authorities to detect smuggled, prohibited, or undeclared goods, verify correct declaration and valuation, prevent evasion of customs duty. Q3. What can be examined under Section 44? Answer. Customs officers can examine imported goods, export goods, baggage of passengers, containers and packaging, any conveyance carrying goods. Q4. Who can exercise the power under Section 44? Answer. Any customs officer who is duly authorized under the Customs Act may conduct an examination. Q5. Does the officer need any special permission to examine goods? Answer. No. No prior court order or permission is needed. The power is statutory and can be exercised during routine customs checks. Q6. Does Section 44 apply only at ports and airports? Answer. No. Section 44 applies anywhere within customs jurisdiction, including ports and airports, inland customs stations, customs bonded warehouse, roads or transport terminals. Q7. Can sealed or secured containers be opened? Answer. Yes. If necessary, customs officers can open sealed containers or packages after recording the opening to inspect the contents. Q8. Do passengers have to cooperate? Answer. Yes. Passengers must open luggage or provide access when required by customs officers lawfully performing an inspection. Q9. What happens if someone obstructs examination under Section 44? Answer. Obstruction may lead to penalties, seizure of goods, further legal action under the Act. Q. Thus, is Section 44 a charging section? Answer. No. Section 44 is not a charging section. It is an enforcement and procedural provision to assist in enforcement of customs laws. Q11. How is Section 44 different from Section 43, screening X-ray? Answer. Section 43. Power to screen or X-ray baggage and goods. Section 44. Power to physically examine goods and baggage. Q. Bara. Why should importers and passengers understand Section 44? Answer. So they know. Customs have authority to inspect goods. Cooperation is mandatory. Inspection helps ensure legal and safe clearance. FAQs on Customs Act 1962 Section 45. Restrictions on custody and removal of imported goods. Q8. What is Section 45 of the Customs Act 1962 about? Answer. Section 45 deals with the custody, control, and removal of imported goods after they are unloaded and before they are cleared by customs. Q2. Who has custody of imported goods under Section 45? Answer. Imported goods remain in the custody of a custodian approved by the Commissioner of Customs until clearance. Q3. Who is a custodian? Answer. A custodian is a person or authority approved by customs to receive, store, and handle imported goods, such as Port Trust, Airport Authority, Container Freight Station (CFS), Inland Container Depot (ICD). Q4. Can imported goods be removed without customs permission? Answer. No. Imported goods cannot be removed from customs control without permission of the proper officer. Q5. Why does Section 45 restrict removal of goods? Answer. To ensure customs duty is properly assessed and paid. Prevention of unauthorized removal or smuggling. Proper accounting of goods. Q6. Does Section 45 apply immediately after unloading? Answer. Yes. Once goods are unloaded, Section 45 applies until clearance for home consumption or warehousing. Q7. What duties does the custodian have? Answer. The custodian must keep goods safe and secure, prevent pilferage or loss, allow access to customs officers, not remove goods without customs permission. Q8. What happens if goods are removed illegally? Answer. Illegal removal may lead to confiscation of goods, penalty on the person responsible, action against the custodian. Q9. Does Section 45 apply to baggage? Answer. Yes. Section 45 also applies to unaccompanied baggage under customs control. Q. Thus, is Section 45 a charging section? Answer. No. Section 45 is not a charging section. It is a control and custody provision. Q11. How is Section 45 linked with other sections? Answer. Section 31, 34, Unloading and Supervision. Section 45, Custody of Imported Goods. Section 46, Clearance of Goods, Bill of Entry. Q12. Why is Section 45 important for importers? Answer. It ensures goods are properly accounted for, released only after legal compliance, protected until customs clearance. FAQs on Customs Act 1962, Section 46. Entry of goods on importation, Bill of Entry. Q8. What is Section 46 of the Customs Act 1962 about? Answer. Section 46 deals with the filing of Bill of Entry for clearance of imported goods. Q2. What is a Bill of Entry? Answer. A Bill of Entry is a legal document filed by the importer giving details of imported goods, value and classification, duty payable, for customs clearance. Q3. Who is required to file the Bill of Entry? Answer. The importer or his authorized customs broker is required to file the bill of entry? Q4. When should the bill of entry be filed? Answer. It should be filed before arrival of goods or after arrival of goods within the prescribed time. Q5. Can the bill of entry be filed electronically? Answer. Yes. Bill of entry is generally filed electronically online through the customs system. Q6. What types of bill of entry are there? Answer. There are mainly three types. Bill of entry for home consumption, bill of entry for warehousing, ex-bond bill of entry for clearance from warehouse. Q7. Is filing of bill of entry mandatory? Answer. Yes. Imported goods cannot be cleared without filing a bill of entry. Q8. What details are required in a bill of entry? Answer. Details include importer's name, description of goods, quantity and value, classification HS code, duty calculation. Q9. Who assesses the bill of entry? Answer. The importer does self-assessment, which is then verified or reassessed by the proper officer under Section 17. Q10. Can a bill of entry be amended? Answer. Yes. Amendment is allowed by the proper officer, subject to conditions. Q11. What happens if bill of entry is not filed? Answer. Failure may lead to delay in clearance, demurrage charges, penalty under the Customs Act. Q12. Is Section 46 a charging section? Answer. No. Section 46 is not a charging section. Duty is levied under Section 12. Q13. Why is Section 46 important? Answer. Because customs clearance begins only after filing of bill of entry, making it a crucial procedural provision. Q14. How is Section 46 linked with other sections? Answer. Section 45. Custody of imported goods. Section 46. Bill of entry. Section 17. Assessment of duty. FAQs on Customs Act 1962, Section 46. Entry of goods on importation, bill of entry. Q8. What is Section 46 of the Customs Act 1962? Answer. Section 46 deals with the mandatory filing of a bill of entry for imported goods to obtain customs clearance. Q2. Who is required to file the bill of entry? Answer. The importer or his authorized customs broker must file the bill of entry. Q3. What is a bill of entry? Answer. A bill of entry is a legal document that contains details of imported goods such as description, quantity, value, classification, duty payable. Q4. When should the bill of entry be filed? Answer. It can be filed before arrival of the goods or after arrival within the prescribed time. Q5. Is electronic filing allowed under Section 46? Answer. Yes. Filing of bill of entry is generally done electronically, online. Q6. What are the types of bill of entry? Answer. Main types include bill of entry for home consumption, bill of entry for warehousing, ex-bond bill of entry. Q7. Is filing of bill of entry compulsory? Answer. Yes. Without filing a bill of entry, imported goods cannot be cleared. Q8. Who assesses the bill of entry? Answer. The importer does self-assessment, which may be verified or reassessed by the proper officer under Section 17. Q9. Can a bill of entry be amended? Answer. Yes. Amendment is allowed by the proper officer of customs, subject to conditions. Q. Thus, what happens if the bill of entry is not filed? Answer. It may result in delay in clearance, demurrage charges, penalty under the Act. Q11. Is Section 46 a charging section? Answer. No. Section 46 is not a charging section. Duty is levied under Section 12. Q12. Why is Section 46 important? Answer. It is the starting point of customs clearance for imported goods. FAQs on Customs Act 1962, Section 47. Clearance of goods for home consumption. Q1. What is Section 47 of the Customs Act 1962 about? Answer. Section 47 deals with the clearance of imported goods for home consumption after assessment of duty. Q2. What is meant by home consumption? Answer. Home consumption means use of goods within India after payment of applicable customs duty. Q3. When are imported goods cleared for home consumption? Answer. Goods are cleared when bill of entry is filed under Section 46. Duty is assessed under Section 17. Duty, interest, and charges are paid. Q4. Who grants clearance for home consumption? Answer. The proper officer of customs grants clearance. Q5. What document authorizes clearance under Section 47? Answer. The order for clearance for home consumption, often called out of charge, authorizes release of goods. Q6. Is payment of duty mandatory before clearance? Answer. Yes. Customs duty and other charges must be paid before clearance unless exempted. Q7. Can goods be cleared without payment of duty? Answer. Only if goods are fully exempt or cleared under special provisions like warehousing. Q8. Does Section 47 apply to warehouse goods? Answer. No. Warehouse goods are cleared under Section 68, not Section 47. Q9. What happens if duty is not paid on time? Answer. Goods will not be cleared and interest or penalty may apply. Q. Thus, is Section 47 linked with other sections? Answer. Yes. Section Paz, custody of goods. Section 46, bill of entry. Section 17, assessment of duty. Section 47, clearance for home consumption. Q11. Is Section 47 a charging section? Answer. No. Section 47 is not a charging section. Duty is charged under Section 12. Q12. Why is Section 47 important? Answer. It marks the final step for release of imported goods into the Indian market. FAQs on Customs Act 1962, Section 48. Procedure in case of goods not cleared, warehoused, or transshipped within prescribed time. Q8. What is Section 48 of the Customs Act 1962 about? Answer. Section 48 deals with the procedure when imported goods are not cleared for home consumption, warehoused, or transshipped within the prescribed time after unloading. Q2. What is the prescribed time under Section 48? Answer. Generally, goods must be cleared, warehoused, or transshipped within 30 days from the date of unloading, or within such extended time as allowed by customs. Q13. What happens if goods are not cleared within the prescribed time? Answer. The goods may be sold by customs authorities or disposed of as per law after following due procedure. Q4. Who has the power to sell such goods? Answer. The proper officer of customs or the custodian with customs permission may sell the goods. Q5. Is notice given before sale of goods? Answer: yes. Notice is given to the importer unless goods are perishable, hazardous, likely to deteriorate. Q6. How are sale proceeds used? Answer: sale proceeds are applied to customs duty and charges, warehouse or custodian charges, expenses of sale. Remaining balance, if any, is paid to the importer. Q7. Can the importer still clear the goods before sale? Answer: yes. The importer may clear the goods before the actual sale, subject to payment of duty and charges. Q8. Does Section 48 apply to warehouse goods? Answer: no. Section 48 applies to goods not warehoused within the prescribed time. Q9. Does Section 48 apply to baggage? Answer: yes. It can apply to unclaimed or uncleared baggage. Q10. Is Section 48 a charging section? Answer: no. Section 48 is not a charging section. It is a procedural provision. Q11. Why is Section 48 important? Answer: it ensures avoidance of congestion at ports and airports, timely disposal of uncleared goods, protection of customs and custodian interests. Q12. Is extension of time possible under Section 48? Answer: yes. The proper officer may extend the time limit on sufficient grounds. FAQs on Customs Act 1962, Section 49. Storage of imported goods in warehouse pending clearance. Q8. What is Section 49 of the Customs Act 1962 about? Answer: Section 49 allows temporary storage of imported goods in a warehouse when immediate clearance for home consumption or warehousing is not possible. Q2. When can Section 49 be used? Answer: it is used when importer is unable to clear goods immediately, or documents are incomplete, or assessment or examination is pending. Q3. Is payment of customs duty required under Section 49? Answer: no. Customs duty is not required to be paid immediately for goods stored under Section 49. Q4. Who grants permission for storage under Section 49? Answer: the proper officer of customs grants permission. Q5. Where are goods stored under Section 49? Answer: goods are stored in a customs-approved warehouse or other place as permitted by customs. Q6. What is the difference between Section 49 and warehousing under Section 59? Answer: Section 49. Temporary storage pending clearance decision. Section 59. Formal warehousing after filing bill of entry for warehousing and execution of bond. Q7. Is there a time limit for storage under Section 49? Answer: yes. Storage is allowed for a limited period as specified by the customs officer. Q8. Can goods stored under Section 49 be sold? Answer: no. Goods cannot be sold while stored under Section 49 unless converted to a case under Section 48. Q9. Are demurrage or warehouse charges applicable? Answer: yes. Storage charges may be payable to the warehouse or custodian. Q10. Does Section 49 apply to all imported goods? Answer: yes, unless specifically excluded by customs authorities. Q11. Is Section 49 a charging section? Answer: no. Section 49 is not a charging section. Duty is levied under Section 12. Q12. Why is Section 49 important? Answer: it provides flexibility to importers and avoids unnecessary sale of goods when clearance is delayed. FAQs on Customs Act 1962, Section 50. Entry of goods for export, shipping bill or bill of export. Q1. What is Section 50 of the Customs Act 1962 about? Answer. Section 50 deals with the filing of shipping bill or bill of export for export of goods from India. Q2. What is a shipping bill? Answer. A shipping bill is a legal document filed by the exporter giving details of export goods, value and classification, export incentives or duty drawback, if any. Q3. What is a bill of export? Answer. A bill of export is filed for export of goods by land routes. Q4. Who is required to file the shipping bill or bill of export? Answer. The exporter or his authorized customs broker must file it. Q5. When should the shipping bill be filed? Answer. It should be filed before the goods are loaded for export. Q6. Is electronic filing allowed under Section 50? Answer. Yes. Shipping bills are generally filed electronically, online. Q7. Is filing under Section 50 mandatory? Answer. Yes. Export goods cannot be cleared without filing a shipping bill or bill of export. Q8. What details are required in a shipping bill? Answer. Details include exporter's name, description and quantity of goods, value and classification, export duty, if any, claim of incentives, if applicable. Q9. Who assesses the shipping bill? Answer. The exporter does self-assessment, which may be verified or reassessed by the proper officer under Section 17. Q. Thus. Can a shipping bill be amended? Answer. Yes. Amendment is allowed by the proper officer, subject to conditions. Q11. Is export duty payable under Section 50? Answer. Export duty, if applicable, must be paid before clearance, but the levy is under Section 12, not Section 50. Q12. Is Section 50 a charging section? Answer. No. Section 50 is not a charging section. It is a procedural provision. Q13. Why is Section 50 important? Answer. It is the starting point for export clearance under customs law. Q14. How is Section 50 linked with other sections? Answer. Section 51. Clearance of export goods. Section 17. Assessment of duty. Section 50. Filing of shipping bill of export. FAQs on Customs Act 1962, Section 51. Clearance of export goods. Q8. What is Section 51 of the Customs Act 1962 about? Answer. Section 51 deals with the clearance of goods for export after completion of customs formalities. Q2. When are export goods cleared under Section 51? Answer. Export goods are cleared when shipping bill or bill of export is filed under Section 50. Goods are assessed under Section 17. Export duty, if any, and charges are paid. Goods are found to be in order by customs. Q13. Who grants clearance for export? Answer. The proper officer of customs grants clearance for export. Q4. What is the document order for clearance under Section 51? Answer. The Let Export Order, LEO, is issued, permitting export of goods. Q5. Is payment of export duty mandatory before clearance? Answer. Yes, export duty, if applicable, must be paid before clearance. Q6. Does Section 51 apply to all export goods? Answer. Yes. Section 51 applies to all goods intended for export unless specifically exempted. Q7. Can goods be exported without Leo? Answer: no. Export of goods without let export order is illegal. Q. Art. Is Section 51 applicable to export goods from warehouse? Answer: yes. Export goods may be cleared from warehouse after following prescribed procedure. Q. Law. What happens if goods are exported without clearance? Answer: such goods are liable to confiscation, penalty under the Customs Act. Q. Thus, is Section 51 a charging section? Answer: no. Section 51 is not a charging section. Duty is levied under Section 12. Q. 11. How is Section 51 linked with other sections? Answer: Section 50, Shipping Bill. Section 17, Assessment. Section 51, Clearance of export goods. Q. 12. Why is Section 51 important? Answer: it is the final legal step allowing goods to be exported out of India. FAQs on Customs Act 1962, Section 52. Goods loaded for export to be properly accounted for. Q. 1. What is Section 52 of the Customs Act 1962 about? Answer: Section 52 requires that export goods loaded on a conveyance must be properly accounted for in the prescribed export documents. Q. Though, what is the main objective of Section 52? Answer: to ensure no unauthorized goods are exported. Accurate matching between goods cleared by customs and goods actually loaded. Prevention of smuggling and misuse of export incentives. Q. 3. To which goods does Section 52 apply? Answer: it applies to all goods cleared for export that are loaded on a vessel, aircraft, or vehicle. Q. 4. Who is responsible for accounting the goods loaded for export? Answer: the person in charge of the conveyance, ship, aircraft, or vehicle is responsible for proper accounting. Q. 5. What documents are used to account for export goods? Answer: goods are accounted for through Shipping Bill of Export, Export Manifest, or other prescribed documents. Q. 6. When should the accounting of goods be done? Answer: accounting must be done after loading and within the prescribed time as per customs rules. Q. 7. What happens if goods loaded are not properly accounted for? Answer: failure may lead to penalty, confiscation of goods, action against the person in charge under the Act. Q. Art. Does Section 52 apply after let export order, Leo? Answer: yes. Even after Leo under Section 51, goods must be properly accounted for once loaded. Q. No. Is Section 52 applicable to coastal exports? Answer: it mainly applies to exports to places outside India. Coastal movement is governed by separate provisions. Q. Thus, is Section 52 a charging section? Answer: no. Section 52 is not a charging section. It is a procedural and control provision. Q. 11. How is Section 52 linked with other sections? Answer: Section 50 Filing of Shipping Bill. Section 51 Clearance of Export Goods, Leo. Section 52 Accounting of Goods Loaded for Export. Q. 12. Why is Section 52 important for exporters and carriers? Answer: it ensures compliance, avoids penalties, and confirms that only authorized goods. You said FAQ on Custom Act Section 53. ChatGPT said, here are FAQs, frequently asked questions, on Section 53 of the Customs Act 1962 explained in simple English, no images. FAQs on Customs Act 1962, Section 53. Goods brought for export not to be loaded unless cleared. Q. 1. What is Section 53 of the Customs Act 1962 about? Answer. Section 53 provides that export goods brought to a customs port, airport, or land customs station cannot be loaded on a conveyance unless they are cleared by customs. Q though, what is the main purpose of Section 53? Answer. To ensure that only legally cleared export goods are loaded and exported, thereby preventing illegal exports and smuggling. Q3. To which goods does Section 53 apply? Answer. Section 53 applies to all goods brought for export from India. Q4. What is meant by cleared by customs under Section 53? Answer. Cleared by customs means shipping bill of export filed, Section 50. Assessment completed, Section 17. Let export order, Leo, granted, Section 51. Q5. Can export goods be loaded before let export order, Leo? Answer. No. Goods cannot be loaded before Leo is granted, except with specific permission of customs authorities. Q6. Who is responsible for ensuring compliance with Section 53? Answer. The person in charge of the conveyance, ship, aircraft, or vehicle is responsible. Q7. What happens if goods are loaded without customs clearance? Answer. Such goods are liable to confiscation, penalty under the Customs Act. Q8. Does Section 53 apply after goods enter the port area? Answer. Yes. Even after goods enter the customs area, loading is prohibited until customs clearance is obtained. Q9. Is Section 53 applicable to all modes of export? Answer. Yes. It applies to export by sea, air, land routes. Q thus. Is Section 53 a charging section? Answer. No. Section 53 is not a charging section. It is a procedural and control provision. Q11. How is Section 53 linked with other sections? Answer. Section 50. Shipping bill of export. Section 51. Let export order. Section 52. Accounting of export goods. Section 53. Restriction on loading without clearance. Q12. Why is Section 53 important for exporters and carriers? Answer. It ensures legal compliance, avoids penalties, and confirms that only authorized goods leave India. FAQs on Customs Act 1962, Section 54. Permission for transshipment of goods without payment of duty. Q8. What is Section 54 of the Customs Act 1962 about? Answer. Section 54 allows transshipment of imported goods from one conveyance to another without payment of customs duty, subject to conditions. Q though, what is meant by transshipment? Answer. Transshipment means transferring goods from one vessel aircraft vehicle to another vessel aircraft vehicle for onward movement to another destination. Q3. Why is Section J1 important? Answer. It facilitates international trade, movement of goods to another customs station or foreign destination, avoidance of double handling and duty payment. Q4. Who grants permission for transshipment under Section 54? Answer. The proper officer of customs grants permission for transshipment. Q5. Is payment of customs duty required for transshipment? Answer. No. Customs duty is not required to be paid if goods are transshipped under Section 54. Q6. Are there any conditions for allowing transshipment? Answer. Yes. Conditions may include execution of bond or security, compliance with customs procedures, movement under customs supervision. Q7. Does Section 54 apply to both imported and export goods? Answer. Section 54 mainly applies to imported goods intended for transshipment. Q. Art. Can goods be transshipped to another customs station in India? Answer. Yes, goods can be transshipped to another customs port or airport in India. A foreign destination. Q. No. What happens if transshipped goods are diverted illegally? Answer. Illegal diversion may result in demand of customs duty, penalty and confiscation. Q. Thus, is Section 54 a charging section? Answer. No. Section 54 is not a charging section. It is a facilitative provision. Q. 11. How is Section 54 linked with other sections? Answer. Section 12 Levy of duty. Section 45 Custody of imported goods. Section 54 Transshipment without payment of duty. Q. 12. Why is Section 54 important for trade? Answer. It enables smooth movement of goods, reduces logistics costs, and supports India's role as a transshipment hub. FAQs on Customs Act 1962, Section 55. Coastal goods to be loaded only at customs ports or coastal ports. Q. 1. What is Section 55 of the Customs Act 1962 about? Answer. Section 55 provides that coastal goods shall be loaded only at a customs port, coastal port, or other approved place. Q. Though, what are coastal goods? Answer. Coastal goods are goods transported by sea from one place in India to another place in India. Q. 3. Why does Section 55 regulate loading of coastal goods? Answer. 2. Prevent mixing of coastal and imported export goods. Ensure customs control. Avoid smuggling and misuse. Q. 4. Where can coastal goods be loaded? Answer. Coastal goods can be loaded only at a customs port or a coastal port or any other place approved by customs authorities. Q. 5. Who is responsible for compliance with Section 55? Answer. The person in charge of the vessel carrying coastal goods is responsible. Q. 6. Can coastal goods be loaded at a non-approved place? Answer. No. Loading coastal goods at a non-approved place is prohibited, except with special customs permission. Q. 7. What happens if coastal goods are loaded in violation of Section 55? Answer. Such goods may be confiscated, subject to penalty under the Customs Act. Q. 8. Does Section 55 apply to foreign-going vessels? Answer. No. Section 55 applies specifically to coastal vessels carrying coastal goods. Q. No. Is Section 55 a charging section? Answer. No. Section 55 is not a charging section. It is a procedural and control provision. Q. Thus, why is Section 55 important? Answer. It ensures clear separation between coastal and foreign trade, proper customs supervision, prevention of illegal movement of goods. Q. 11. How is Section 55 linked with other sections? Answer. Section 7 Customs Ports. Section 33, 34 Loading Unloading under supervision. Section 55 Loading of coastal goods. Q. 12. Who benefits from Section 55? Answer. It benefits customs authorities, better control, genuine traders, fair trade practices, government revenue. FAQs on Customs Act 1962, Section 56. Coastal goods to be accompanied by Bill of Coastal Goods. Q. 1. What is Section 56 of the Customs Act 1962 about? Answer. Section 56 requires that coastal goods carried by sea from one Indian port to another must be accompanied by a bill of coastal goods. Q2. What are coastal goods? Answer. Coastal goods are goods transported by sea between two places in India, coastal trade. Q3. What is a bill of coastal goods? Answer. A bill of coastal goods is a document containing details of the coastal cargo, similar in purpose to a shipping bill but meant for coastal movement. Q4. Who is required to file the bill of coastal goods? Answer. The person in charge of the vessel carrying coastal goods is responsible for filing it. Q5. When should the bill of coastal goods be filed? Answer. It must be filed before the coastal goods are loaded on the vessel within the prescribed time. Q6. Why is Section 56 important? Answer. It helps maintain customs control over coastal movement, prevent mixing of coastal and foreign-going cargo, avoid smuggling and misuse of coastal trade. Q7. Is customs duty payable on coastal goods under Section 56? Answer. No. Customs duty is not payable on genuine coastal goods. Section 56 is a procedural requirement. Q8. What happens if coastal goods are carried without a bill of coastal goods? Answer. Such goods may be confiscated, subject to penalty under the Customs Act. Q9. Does Section 56 apply to all coastal vessels? Answer. Yes. It applies to all vessels carrying coastal goods between Indian ports. Q. Thus, is Section 56 a charging section? Answer. No. Section 56 is not a charging section. It is a procedural and control provision. Q11. How is Section 56 linked with other sections? Answer. Section 55. Loading of coastal goods at approved places. Section 56. Bill of coastal goods. Section 7. Customs ports. Q12. Why should carriers and traders know Section 56? Answer. To ensure smooth coastal movement, avoid penalties, and comply with customs documentation requirements. FAQs on Customs Act 1962, Section 57. Appointment of public warehouse. Q8. What is Section 57 of the Customs Act 1962 about? Answer. Section 57 empowers the Principal Commissioner or Commissioner of Customs to appoint public warehouse where imported goods may be stored. Q2. What is a public warehouse? Answer. A public warehouse is a customs-approved place where imported goods can be stored by any importer subject to customs control. Q3. Who has the power to appoint public warehouse? Answer. The Principal Commissioner or Commissioner of Customs has the authority to appoint public warehouse. Q4. Why are public warehouse appointed? Answer. 2. Facilitate storage of imported goods. Allow deferment of customs duty. Reduce port congestion. Q5. Can any place be appointed as a public warehouse? Answer. No. Only places that meet customs requirements and are officially approved can be appointed. Q6. Are public warehouse open to all importers? Answer. Yes. Any importer can store goods in a public warehouse, subject to compliance with customs rules. Q7. Is customs duty payable immediately for goods stored in a public warehouse? Answer. No. Customs duty is payable only when goods are cleared from the warehouse for home consumption. Q8. How is Section 57 linked with Section 9? Answer. Section 9 Declaration of Warehousing Stations. Section 57 appointment of public warehouse within those stations. Q. No. Is Section 57 a charging section? Answer. No. Section 57 is not a charging section. It is an administrative provision. Q. Thus, can the appointment of a public warehouse be cancelled? Answer. Yes. The Commissioner may cancel or modify the appointment if conditions are violated. Q. 11. What obligations do public warehouse operators have? Answer. They must follow customs directions, ensure safe custody of goods, allow customs access and supervision. Q. 12. Why is Section 57 important? Answer. It supports trade facilitation, duty deferment, and efficient customs administration. FAQs on Customs Act 1962, Section 58. Licensing of private warehouse. Q. 1. What is Section 58 of the Customs Act 1962 about? Answer. Section 58 empowers the Principal Commissioner or Commissioner of Customs to license private warehouse for storage of imported goods. Q. 2. What is a private warehouse? Answer. A private warehouse is a customs licensed warehouse used by a specific importer for storing his own imported goods. Q. 3. Who can apply for a private warehouse license? Answer. An importer or owner of goods can apply for a license to operate a private warehouse. Q. 4. Why would an importer prefer a private warehouse? Answer. 2. Store goods near own premises. Have better control over inventory. Defer payment of customs duty. Q. 5. Who grants the private warehouse license? Answer. The Principal Commissioner or Commissioner of Customs grants the license. Q. 6. Are there conditions attached to the license? Answer. Yes. The license is granted subject to conditions such as execution of bond, provision of security, compliance with customs rules. Q. 7. Is customs duty payable immediately for goods stored in a private warehouse? Answer. No. Customs duty is payable only when goods are cleared from the warehouse for home consumption. Q. 8. Can the license under Section 58 be cancelled? Answer. Yes. The license may be suspended or cancelled if conditions are violated. Q. No. How is Section 58 different from Section 57? Answer. Section 57, Public Warehouse, open to all importers. Section 58, Private Warehouse, for a specific importer. Q. Thus, is Section 58 a charging section? Answer. No. Section 58 is not a charging section. Duty is levied under Section 12. Q. 11. Does Section 58 apply only to imported goods? Answer. Yes. It applies to imported goods intended to be stored without immediate payment of duty. Q. 12. Why is Section 58 important? Answer. It promotes ease of doing business, inventory flexibility, and efficient customs management. FAQs on Customs Act 1962, Section 59. Warehousing Bond. Q. 1. What is Section 59 of the Customs Act 1962 about? Answer. Section 59 deals with the execution of a warehousing bond for storage of imported goods in a warehouse without immediate payment of customs duty. Q. Though, when is a warehousing bond required? Answer. A warehousing bond is required before goods are deposited in a warehouse under the Customs Act. Q. 3. Who is required to execute the warehousing bond? Answer. The importer or the owner of the goods must execute the bond. Q. 4. What is the purpose of a warehousing bond? Answer: to secure. Customs duty payable. Interest, penalty, or other charges, if any, in case of non-compliance. Q5. What is the amount of the warehousing bond? Answer: the bond is generally executed for an amount equal to the duty assessed on the goods. Q6. Is security required along with the bond? Answer: yes. The proper officer may require security or surety as deemed fit. Q7. Does Section 59 apply to both public and private warehouse? Answer: yes. Section 59 applies to both public, Section 57, and private, Section 58, warehouse. Q8. Is customs duty payable at the time of warehousing? Answer: no. Duty is deferred and payable only when goods are cleared from the warehouse for home consumption. Q9. What happens if goods are not cleared properly from the warehouse? Answer: the bond may be enforced and duty, interest, and penalties may be recovered. Q10. Is Section 59 a charging section? Answer: no. Section 59 is not a charging section. Duty is levied under Section 12. Q11. How is Section 59 linked with other sections? Answer: Section 57, public warehouse. Section 58, private warehouse. Section 59, warehousing bond. Section 68, clearance from warehouse. Q12. Why is Section 59 important? Answer: it ensures revenue protection while allowing importers the benefit of duty deferment. FAQs on Customs Act 1962, Section 60. Permission for deposit of goods in a warehouse. Q8. What is Section 60 of the Customs Act 1962 about? Answer: Section 60 empowers the proper officer of customs to permit deposit of imported goods in a warehouse. Q2. When is permission under Section 60 required? Answer: permission is required after filing the bill of entry for warehousing and before goods are deposited in the warehouse. Q3. Who grants permission under Section 60? Answer: the proper officer of customs grants permission. Q4. Is assessment of duty required before granting permission? Answer: yes. Goods must be assessed to duty before permission to warehouse is granted. Q5. Is payment of duty required at the time of warehousing? Answer: no. Duty payment is deferred until goods are cleared from the warehouse. Q6. What document evidences permission under Section 60? Answer: the order of the proper officer permitting deposit of goods in the warehouse. Q7. Can permission under Section 60 be refused? Answer: yes. Permission may be refused if conditions of warehousing are not fulfilled. Required bond under Section 59 is not executed. Q8. Does Section 60 apply to both public and private warehouse? Answer: yes. It applies to both public and private warehouse. Q9. What happens after goods are deposited under Section 60? Answer: goods come under customs control and remain in the warehouse until cleared under Section 68 or otherwise disposed. Q10. Is Section 60 a charging section? Answer: no. Section 60 is not a charging section. Duty is levied under Section 12. Q11. How is Section 60 linked with other sections? Answer: Section 46, Bill of Entry. Section 59, Warehousing Bond. Section 60, Permission to Warehouse. Section 68, Clearance from Warehouse. Q12. Why is Section 60 important? Answer: it enables legal warehousing of goods and allows deferment of customs duty benefiting importers.